Hello everyone, welcome to Laexcellence IAS Academy. We will continue with our article series. Okay, let us begin. In this video, we will start with article 102 and 191. These both articles deals with disqualification of MPs and MLAs. Article 102 deals with the disqualification of MPs. And article 191 deals with the disqualification of MLAs. Again, the article 102 subclause 1 deals with the disqualification of MPs based on office of profit. And article 191 subclause 1 deals with the disqualification of MLAs based on office of profit. Article 102 subclause 2 and article 191 subclause 2 deals with the disqualification of MPs and MLAs based on the defection. First, we will discuss the office of profit. Article 102 subclause 1 and article 191 subclause 1 deals with the office of profit. If any MPs and MLAs has a office of profit, means they are having any office of profit and also seat of MP and MLA. On these grounds, any MP or MLA can be disqualified from the post. But what is office of profit? Is it defined in the Constitution? Is it defined in the article 102 or 191? No. But Supreme Court in Jaya Bachchan versus Union of India defined the office of profit. This office of profit is nothing but which is capable of yielding a profit. Yielding profit or any pecuniary gain. If any MP or MLA has a post which yields a profit or any pecuniary gain, based on that any MP or MLA can be disqualified by using article 102 and 191. Article 191 subclause 2 and article 102 subclause 2 deals with the disqualification of members of parliament and state legislative assemblies with respect to defection. These clauses are added by the 52nd Constitutional Amendment Act of 1985 during Rajiv Gandhi government. But what is defection? Defection is nothing but any MP or MLA voluntarily gives up their party membership. Voluntarily gives up their party membership. If any nominated member joins any political party after 6 months. If he joins any political party after 6 months, that nominated member, he can be disqualified. If any independent candidate who has been elected independently to state legislature or to the parliament, these candidates, if they join any political party, he can be disqualified based on defection. Or if any MP or MLA votes against the instructions of the party in the house, based on that he can be disqualified from the post of MP or MLA. But these defections, who decides whether MP is defected from any post, means whether he can be disqualified from the defection, that is done by the speaker. In case of Lok Sabha speaker, in case of state legislative assembly, the speaker of that particular assembly will decide of the defection of these members. Particularly, article 93 and 198 deals with the posts of speaker and deputy speaker at the central level and speaker and deputy speaker at the state level, mean state legislative assemblies. Article 93 deals with the speaker of the central level and article 178 deals with the speaker at the state levels. The speaker decides the defection of members. With respect to office of profit, the disqualification of members done by the president, not by the Supreme Court but by the president. But before president makes any decision with respect to disqualification of members, the Election Commission of India should submit a report to the president. Based on that, president takes action and any member or any MP or any MLA can be disqualified based on the report of Election Commission of India by the President. With respect to defection, Speaker will take decision. But the issue with respect to Speaker is that there is no time limit to consider the request of the defection. But the decisions taken by the Speaker are binding and also not questionable in any court. But in Kyoto Holohan case in 1992, Supreme Court had said that the decision taken by the Speaker with respect to defection can be questioned in any court of law based on misuse of the power. And also in Kisham Meghachandra Singh case of 2020, Supreme Court had said that the Speaker has to decide the cases with respect to defection within 3 months. Means the first time the Supreme Court set a time period for the Speaker to decide on the matters of defection. Very important other case with respect to defection is Nabab Rebia case. In this particular Nabab Rebia case in 2016, Supreme Court had said that Speaker can't decide on the matters of defection if there is any motion is against the removal of Speaker is passed in the House. Simple. If there any motion is passed for the removal of the Speaker in any house, for example in the Lok Sabha or in state legislative assemblies, in that time Speaker can't decide on the matters of defection. This is Supreme Court had said in Nabab Rebia case. These are the three important cases with respect to defection and also with respect to Speaker. And these are Article 102 and 191 deals with the defection, and we also discussed about Article 93 and 178 which deals with the post of the Speaker and Deputy Speaker at the central and state level. Hope you got an idea with respect to all these articles. Thank you.